What estate planning documents do you need while you're still alive? Well, the answer to this may surprise you. Tune in now to listen to attorney Joseph Marra as he explains the power of attorney, living wills, healthcare proxies, and directives for funeral arrangements.
Erica, one thing people don't really consider when they come in and say, I really want a will, and they're worried about them dying. What people don't realize is that as the population gets older, we have more of a chance of being disabled before we die than there ever was before. So, especially if you're younger and with children, you don't think about these things. But there's more of a possibility that you can be disabled, and you really have to plan for that disability. And in New York State, the operative document is a healthcare proxy. So when you have a healthcare proxy, once you can no longer make healthcare decisions for yourself, that person will step in for you. And many people will say, well, it would normally be my wife. Well, it normally would be. What if your wife's disabled? What if things go on and God forbid your wife predeceases you, your husband predeceases you, you get divorced? Then who's going to make the decisions for you? So you really need to have the operative document where, okay, if I can't make decisions for me, someone else is going to do it for me. And the operative document in New York is called the healthcare proxy. There are other documents as well we're going to talk about briefly. A living will, there's something called a mulched, a pulsed. Those are not, the mulched and the pulsed are not really used that frequently, but they are on the books, something you should know about. But for your healthcare proxy. And what dovetails with that is the living will. Now, the term is kind of amorphous because you think a will is to when you die. That this is for when you're alive, right? And a living will is basically a statement by you that says, look, if I am brain dead, pull the plug. Just give me pain medication. I don't want to be brain dead and linger on forever. Now, other people have different views. They say, well, if I am brain dead, keep me alive as long as possible. You could put that in your healthcare proxy and in your living will. Now, some people just leave in their healthcare proxy, well, my agent knows what I want. I don't think that's a good idea. I think you need to put these statements as to what you want in your healthcare proxy and in a living will, because the living will is your declaration as to what you want to have happen. And the healthcare proxy, it empowers the person to act for you if you can. So both very, very important documents where you can say, hey, if there's no more brain function, give me medicine to make me comfortable, withhold food and water, and let me pass rather than being around indefinitely. For those of you who are a little older, you might remember years ago there was a case in New Jersey, Karen Ann Quinlan. She was a young woman who basically became brain dead, and her family fought in court to have her taken off life support systems. And it was front page papers in the 60s and 70s. And unfortunately, this woman lasted a very long time. And when the family finally won, they still wouldn't pull the feeding tube out of her in the water. So she basically lingered as a vegetable for years. I know personally, I wouldn't want that to happen to me or to a loved one. And you really need to make that statement and declaration and have it done. And once it's done, you shouldn't take it, stick it in the drawer. You should bring it to your primary care doctor, bring it to any doctor that you know you're going to see. And more importantly, if you're going into the hospital and you know you're going to the hospital, bring it with you. So you're having elective surgery, here's my healthcare proxy. They have it. The hospital people do appreciate that. Sometimes in New York, they give you a standard New York form, say, fill this out. You don't know what you're filling out. You're under stress. You may not put in everything you want into that document. Have one done, drafted properly by an attorney with all the relevant information and all your wishes and desires in the document. Very important. And make sure that your proxy has a copy, and when you go to the hospital, that you bring it with you. One other thing with this, name a backup. Say, well, I named my wife. Well, what if your wife dies before you? I always tell people, name two backups. If A can't do it, then B. If B can't do it, then C. So you know. And one more document that kind of goes hand in hand with this is an advance directive with respect to funeral arrangements. So you give the same people the power to make your funeral arrangements for you. If you have, say you have no spouse and you have a few kids and you don't want your kids fighting, we'll give someone the power to do these things and make them be the person in charge. Don't say, well, oh, you know, all my kids get along. They'll decide this together. Well, after so many years of doing this, I've grown a little cynical, and it may seem that way, but there are a lot of families where they don't get along when these things come, even though they may have gotten along before. So you really need to put somebody in charge, make your wishes known, put it in the documents, and make sure the proper people have those documents. The living will is the declaration by you that says, pull the plug. It basically sets your desires and your wishes as to what to do in the event you are brain dead. That's the living will. That's the living will component of this. So you have three, I use three main documents: the living will, which is your declaration, your statement; the healthcare proxy, which incorporates your statement in it, but gives someone the power to act for you, to make healthcare decisions for you if you can't; and then the advance directive with respect to funeral arrangements, where you set forth who's going to make those arrangements and what you want done. I mean, some people, I had one client tell me that he wanted a big party. He wanted it the day of a New York Giant game. He had it all laid out, what the hell things were going to do, how his funeral was going to go, and we put that in his advance directives with respect to funeral arrangements. It was all laid out. So you can put that in there too. And then usually when they do that, I also put similar provisions in the will. So there's two documents showing the same desires. Now, the one thing we didn't discuss, because remember, everything we've discussed so far, living will, healthcare proxy, and your advance directive with respect to funeral arrangements have nothing to do with finances. Okay, absolutely nothing. So another very important document is the power of attorney. Now, I have some clients who get very leery about this document, and for good reason, but it is an essential estate planning document. And let me tell you first what it does and why you need it, okay? A power of attorney gives someone the power over your finances to the same extent you have it. I'll repeat that. What you can do with your money, they could do. So could they take your money and go to Bolivia? Absolutely. They could clean you out. But you have to, that's the negative side of it, but hopefully you'll pick properly. You'll give someone the power over your finances. People say, well, you know what? I have a will, I have a trust, I have a healthcare proxy. I don't want to do this. Well, you still need it. Let me tell you why. What happens? You become feeble, and now you can't handle your day-to-day bill paying and things like that. No one's going to talk to anyone without a power of attorney. They're just not going to. So there's still, even if you have these other bases covered, if you do not have a power of attorney, there's still going to be holes in your plan. And I understand that people have this fear of giving up control, but remember, here's the thing about power of attorney. Number one, it gives, as I said, complete power over your finances to someone else. Number two, you can cancel it at any time. You have that power. So number three, for power of attorney to really be effective, it has to be what's called a durable, general power of attorney. Durable meaning it survives your disability. So if you're disabled, power of attorney can still act. It used to be that the power of attorneys, because people use them a lot in business transactions, they'd give someone an agency to handle some business for them, and then it would lapse. But over time, it evolved. And you really need this durable power of attorney, because now as we grow older and we live when we're not really mentally and physically capable, you have to give the power to handle your finances to someone. And I've had people say, well, I'll give it to them later. Can't we do something else where they don't have it till later? Well, yes, you can. It's called a springing power of attorney. And what does that mean? Well, it doesn't spring into effect until you're disabled. People go, I like that one. Well, honestly, I will not prepare it. I refuse to prepare it. And people will say, why? Why would you refuse to prepare it? Think about it, okay? But just be practical now. You have this springing power of attorney. You give it to your son. You did it 5 years ago. Now all of a sudden you're in an accident and you can't handle your affairs. And your son now goes to the bank with the springing power of attorney that they've never seen before. And the bank says, we're not honoring this. Why not? Well, it's a springing power of attorney. You have to prove that your father can't act. Well, I'm telling you, it's an accident. No. We want a doctor's certification. Do you really think medical doctors want to get involved in this type of thing? As a practical matter, they generally do not. Okay? So that's why I refuse to give it to, I refuse to prepare them. This is what I recommend my clients do. I say, name 2 people who have equal and separate power to act. And particularly with as a spouse, if you're married, this makes sense. So you would name your spouse and a sibling or your child as your agents. You let them know. And in New York, they have to sign the document. The agent has to sign it in front of a notary. That's called it has to be acknowledged. Right? For it to be effective. So then you also name a backup if the first 2 can't. That's typically what I recommend. You go, well, I'm giving my son this power to go take my money. Yeah, but now if your son, is he going to go do it? If he does, you could stop him, right? And now it's good to know when you give it to him, if he's going to act inappropriately, now you're competent, you're in good shape, you could stop him, you could cancel it. What is the flip side? What are the dangers? Well, here's typical danger. Single woman living in Manhattan, not a case I had, but something, you read about when you're doing your education courses. She was going in for an operation. She had no estate planning documents. And she then said, well, my closest friend and relative is my sister. So she did a power of attorney. She named her sister. Well, she was, I guess, that close to her sister because she didn't realize her sister had a gambling problem and liked to go to Atlantic City a lot. So while this woman was recuperating from her surgery, the sister took $40,000 out of her account and blew it in Atlantic City. And she realized it 2-3 months later when she was able to recover her faculties and start managing her own affairs. That is a danger. But I submit that if she had given maybe the power of attorney earlier to the sister, it wouldn't have been such a new thing when she became disabled, and maybe the sister wouldn't even have thought about it. I don't know, it's possible. That's why I say give the power of attorney and give the broadest powers you can to the person when you're in good shape, when you're competent, and see how they are. If they stick it in the drawer and never do anything, that's great. But at least they'll know that if you're disabled, they can act. Another thing you should do, bring the power of attorney to your banks, to your financial institutions. Some of them will want you to sign their own forms. Great, sign them. But remember, the ones I prepare have certain gift-giving powers that will enable your agent to do Medicaid planning if you have to go to a nursing home, and we'll talk about that later. And also, we'll give them various other powers that the standard forms that the banks utilize don't. And I feel that the broader the powers you give them, the better. For example, typically in real estate transactions, you may have executed a power of attorney a number of years ago. Well, unbeknownst to you, and maybe the attorney you used, a lot of the title companies and banks want to see your specific property named in the power of attorney. Does it have to be? No, legally it doesn't. But what I do is if you have view on properties, I will specifically name those properties in the power of attorney and give your agent the power to handle those. I mean, I try to foresee all contingencies. Can you go get a power of attorney out of the, off a form, off the internet or a form store? Absolutely. Will it be as comprehensive as the one we prepare for you? No, clearly it won't be. And you have to go to an attorney who has some knowledge in estate planning state taxes, elder law. I mean, one time I had a person who I did their documents for pass away. And basically they were ill for quite a while. And they were going to have an estate tax issue. Now, the government will take a snapshot of what you're worth when you pass away. And to the extent you exceed the threshold, they will tax you. So I had a client who I had done work for, and she was very ill, and she was ill for quite a while. And I spoke to her nephew, who was her power of attorney executor, and I said to him, look, your aunt is going to have estate tax issues. She has 10 beneficiaries named in her will. My suggestion is use your power as power of attorney and start giving away some of this money now. That will lower her taxable estate. So we basically got over $150,000 out of her estate. And we filed the estate income tax return, and it was audited by an IRS agent. So what's the first thing he asked me for? I want to see that power of attorney. Looked at it. I said, oh, Mr. Agent, you're looking for the gift-giving power, aren't you? I says, here's the paragraph where he was like, damn it, because that's typically these powers of attorney don't have the proper gift-giving language, which allow people to give money away. And if you're going to be doing any estate tax planning or Medicaid planning, meaning trying to preserve assets and get somebody on Medicaid, you need these things in the power of attorney. So if you're going to do the power of attorney, do it right. Don't buy one off the internet or go to a lawyer who doesn't know anything about Medicaid planning and estate planning. Get it done right.
Thank you so much, Joe, for that important information. And thank you, audience, for watching. If you yourself or someone you know may have questions on this topic, please don't hesitate to pick up the phone and call the law offices of Joseph Marra. They are professional, friendly, and really great at looking at the pros and cons of your situation, coming up with a fantastic strategy, and giving you some options. We look forward to hearing from you soon.